Good afternoon, Chairwoman Rogers and committee members. My name is Jordy Clark, representing the Arizona Association of Counties on behalf of the county attorneys. We respectfully oppose SB 1330. Family law cases, particularly those involving children, require specialized knowledge and training that juries do not always possess. Family court judges are uniquely experienced in child welfare, high conflict family dynamics, and the nuanced application of the best interest of the child standard. Expecting juries without this background to make informed decisions risk outcomes that may not adequately protect children or families. Jury trials would also significantly delay urgent decisions in cases involving abuse, neglect, or substance misuse. These matters often require swift judicial action to ensure child safety, and introducing jury proceedings would slow the process at the very moment when time is most critical. Additionally, jury trials would expose highly sensitive family and child records to a much larger group of people. Confidentiality is essential in family court to protect the privacy, dignity, and long-term well-being of children and parents. Expanding access to those records increases the risk of unnecessary disclosure and harm. Finally, the availability of jury demands would be misused to stall proceedings, drive up litigation costs, and pressure vulnerable parties. This would clog already overburdened civil dockets and significantly increase county expenses, staffing strain, and administrative burdens without improving incomes for the children and family. And we respectfully urge the opposition of SB 1330, and I'm happy to take any questions.
I have a question.
Yes, ma'am.
Are juries ever subject matter experts on the subjects that they pass judgment on?
Chairwoman Rogers, I guess it would depend on the juror, but as a whole, the attorneys believe.
Sure. I mean, the attorneys, if they're in a scam with the judges, are going to believe that. Prove me wrong.
Madam Chair.
I want an answer.
Chairwoman Rogers, at this moment, I wouldn't be able to prove without looking at a group of jurors, and I guess you'd have to ask a specific set of jurors if they're expert matters on what they will be going, but yes, you're correct. Going into any trial, of any kind, you would have to assume that they may or may not be a matter expert.
So I guess to put a point on my question, at any time with any subject, a jury of one's peers are just people who work other jobs, who are normal workaday Americans who are called to become jurors, and then they have to pass judgment on whatever their case is. So I'm perplexed at the notion that jurors have to be, and allegedly are not, but should be, the assumption is from what you've said, subject matter experts on family law. Help me understand why that is significant, please.
Chairwoman Rogers, I apologize. I don't have a full answer that I can give you at this time.
I appreciate your honesty.
All right.
Oh, no, go.